thank you for that introduction, Tony. I'm happy to be joined by my colleague, Kathryn Jones, today. And we are talking about a topic that's in the news. It's ever changing, and you're going to get the flavor of that through the next couple of slides that we go through here. Big picture is that there's a lot of changes coming out with respect to what's law and policy and guidance from different state and federal agencies. This affects us as in operation of our own business and our clients. And quite frankly, I don't know how, especially like a small to medium business size business owner would ever be able to keep up on everything that's happening in the marketplace with the law. So we're going to jump right into it here, and starting with, this is kind of an overview of what we're looking at. We are here in Florida. We realize we have attendees that are outside of Florida oftentimes, but we're going to take a look at federal law and guidance. We'll take a look at Florida law, and just I'm licensed in Nevada and have do work out there on occasion, so we'll touch on Nevada law just to give a different perspective of what the other states may be doing. And first, just from again a broad policy perspective, the vaccine laws, and people are probably aware that there was a lawsuit recently filed by Norwegian Cruise Line against the Florida Surgeon General, where the court invalidated the Florida vaccine passport law as it applies to the cruise lines, and we'll talk about that case at the end when we have a little bit of time. But the takeaway here is going to be that vaccine laws vary from state to state and across jurisdictions, depending on who you get the information from. And so we're going to try and make some sense out of all this throughout the next hour and give you some practical advice and takeaways. Kathryn, what do you think?
Sure. Just to take off on that, in the next few slides, Eric has laid out kind of a chronology and different highlights from different agencies, and you'll see kind of how constantly in flux this area of the law is, to the point where, again, it is, from a practical perspective, hard to imagine how a business owner who is already kind of bombarded with the day-to-day operations is supposed to handle this. And towards the end of the presentation, we'll talk about, in Florida, some civil immunity statutes that may help.
I do like the civil immunity statute. This presentation was actually born out of a demand that came from some clients. Many clients have contacted us asking whether they can require employees get vaccinated, whether they can require proof of vaccination, whether they can require people who are not vaccinated to get masked or wear masks. And so we've actually developed a policy that we've shared with some clients that we believe is in line with the law, that has some flexibility in it. We can modify that policy from client to client. You should have some resource that you can go to, and if you don't have counsel to go to, or if you have other questions, you want to look at some up-to-date information, I really like this website here. It's the OSHA website that has an ongoing frequently asked question page where they do regular updates of new policy and guidance that comes out. OSHA tends to follow the CDC, but they have some unique requirements in that. And OSHA is the organization that's responsible for occupational safety and health and welfare on the workplace. All right, so Kathryn,
you want to go back to I think it was slide 2.
Oh, here.
We're talking about. One more back.
We had the first slide, and then this was just our
so
introduction.
I like kind of how you laid it out here, Eric, where we've got one end of the spectrum where certain laws require proof of vaccination to enter into venues. They may have certain requirements for particular industries. And then on the next slide, we kind of talk about the other end of the spectrum, which is more so what we see in Florida here, is prohibiting government from asking or requiring documentation of vaccination status.
And I think part of it, what we're going to see, especially like with the Florida law, while regardless of what you think of the policy.
Can I get you guys to speak louder, please?
Sure. Let's move this speaker here, make sure everybody's catching us. Regardless of what you think of the policy, the statutes came into play fast, and the law recognizes that. Or the courts rather recognize that, I believe, in that opinion, that this was really, when you read the opinion from the Norwegian case, you can see that it probably could have been a little more thorough in the drafting, and I'm sure that will probably happen on the next go round. So we'll start with an overview on the federal here, and we've got, we're going to go back to the beginning of 2021 and the end of last year. And I just thought one of the issues that jumped out here on this Department of Labor, and this is if you ever have dealt with as an employer a wage and hour claim, you're under the Department of Labor Guidance and Regulations. And here there was a question about whether or not employees who work from home and at work, and we know a lot of clients who have done that, who've implemented that type of work arrangement with their employees, that they spend some time at home working and in the office, so it's a hybrid. And is the time spent between the two locations considered telework, or two locations considered the travel time between the two locations? Is that compensable if you're going from in-office work to telework? And the guidance from Department of Labor said that it is not compensable as working time. They also passed some rules regarding in-home caregivers who are working shifts of 24 hours or more. And then we have President Biden gets into office, signs an executive order requiring the Secretary of Labor to issue revised OSHA guidance. And again, if you go back to the OSHA frequently asked questions page, you see where OSHA has made continuous updates to their policy and guidance. Here we've got April of 2021, CDC issuing updated guidance. And this is where the CDC said that individuals no longer need to wear, vaccinated individuals no longer need to wear masks outside, or if they're in venues, unless they're in a crowded venue or setting, and reduced some of the exposure, or rather the risks of recognizing that there was reduced risk for vaccinated individuals, therefore reducing some of the restrictions that were imposed on those individuals that have been vaccinated. Important takeaway here is when we see CDC guidance, people refer to this as a law, and I know this has come up a lot in the context of the CDC restrictions on whether or not you can force evictions or foreclose on properties where people weren't paying. The CDC does not make law. The CDC can issue guidance. The CDC can issue regulations, but unless it's an adopted regulation, if it's just guidance, that's not law. It's exactly what it sounds. It's guidance for courts. So when the CDC guidance bumps up against something like a Florida statute or a federal statute, the courts can take into account the guidance, but it doesn't mandate what individuals and business owners need to be doing as far as legal compliance. All right, so in May, we have CDC issuing updated guidance, again, resuming activities without wearing a mask. And this has been the hot button issue, is what can folks do with or without a mask? And then let's go on to the next part here. So I want to have time to talk about these other issues. Here we have May of 2021. Again, a lot happening very fast. We've got Equal Employment Opportunity Commission. They have also some Q&A on their website, and they updated their technical assistance Q&A to essentially state that under the ADA, which is the Americans with Disabilities Act, and other federal equal opportunity laws, employers may offer incentives to employees to voluntarily receive the COVID vaccine, but the incentive can't be so much that it's considered coercive. So this goes to the question of, can I require my employees to have to get vaccinated? And the answer is no, except in certain settings. Generally, the answer to that question is going to be no. You cannot require the employees to be vaccinated, But you can offer incentives, and that's sort of the policy approach we've taken. Generally, for most employers, again, with some exceptions, for most employers, you can offer incentives, but you don't want the incentive to be so great that, for instance, it looks like it could be wrongly interpreted by somebody who is not able to be vaccinated, so that they're discriminated against. So you may have folks who, for one health reason or for some other reason, are not able to be vaccinated. So that's a concern. And we also don't want to look like as we're offering too much, so as to coerce people into doing something they otherwise would not do for their own health. But you can offer, as an employer, unlimited incentives to employees who voluntarily provide documentation that they received the vaccine. So you're limited in incentivizing the employees to get the vaccine, but as far as providing proof or documentation, there's no limits. And really, at that point, if somebody's already had the vaccine, what would be the drawback in them provide the documentation? So I think there's a balance there. And then the incentives can be offered only to the employees, not to family members, but they can, as an employer, you can offer to help get family members vaccinated. That's really, I think, a big takeaway for where we stand right now. That's probably the policy that most folks that I talk to have implemented, is sort of a voluntary policy of encouragement. Here we have additional guidance that came out from OSHA, and this again is available on the website. We won't cover all of these directly, but this applies specifically to healthcare employers. So there were two events on June 10th of 2021 where OSHA came out with specific standards for healthcare employers and healthcare workers, and also for high-risk areas such as manufacturing and high traffic retail, and we'll see that one in the next couple of slides. But this is the guidance from OSHA. So if you are a healthcare employer, we represent several healthcare clients. You get treated a little bit differently. You have a little bit more flexibility to require to do screening and have requirements for employees to be vaccinated in order to work. And OSHA requires training to all employees, also requires PPE, respirators, respirator ventilation equipment for folks working around folks who might be suspected of having COVID or being exposed to it. And then, of course, you also have to inform your employees of all anti-discrimination, anti-retaliation rights if they are, for instance, if somebody is going to complain because they didn't get proper PPE. Here's an overview of the guidance recommended for the high-risk workplaces. And some examples, again, include high-volume retail, manufacturing, meat packing was another one that was listed in the guidance. And these are things that, if you think about it, I think a lot of this is, and I don't know what you see, Kathryn, a lot of this are things that we've already seen business owners doing, like staggering break times. When you walk into a lot of retail stores, you see the signs on the floor. We see them when we walk into our business. What have you encountered businesses do not seem to be following these policies?
I mean, I see some that may have scaled back. They may have removed some of their floor signage. I've not, to me, it may just make good sense just from a general health perspective to be doing these things anyway, even without COVID. COVID is probably, the spark, I guess. But these things, I wouldn't be surprised if they stayed in place even after the pandemic passes or becomes more manageable.
And that's another big question, right? What's the effect going to be long-term just on remote work, from a perspective of what we do as lawyers? We are now doing many more meetings with clients in this fashion by video conference. I'm attending hearings. I testified in a hearing yesterday in Nevada, and I testified right from my office here in Florida. In a totally a case not related at all to COVID. So it's really expanded and changed the way that we do business anyway. I think for kids, it certainly seems to help with teaching hygiene and good practices for kids, washing your hands, using hand sanitizer. people started doing that, and it's become a habit. And so that's maybe one of the good byproducts of what we've seen.
But overall, illnesses, kids get flus and respiratory illnesses, and at least in my own household, we've seen far less of that since we're, as a family and also as a society, a little bit more attuned to hand hygiene and other things.
So here we have, this is just a little over a month ago, in July, the Department of Justice working, and there's been a couple opinions that have been issued by the DOJ working with the Federal Trade Commission, and DOJ will work with other entities as well. The Department of Justice enforces a lot of the law and policy that's put into place by these other agencies. So here we've got the Federal Trade Commission and Department of Justice issuing a joint opinion stating that the FDA's emergency use authorizations for the COVID vaccines, that would enable the vaccines to get rushed out faster, on a faster track than they normally would for approval to individuals. Those authorizations do not prohibit entities from imposing vaccine requirements on individuals returning to work or accepting employment. So a couple slides ago, I said that generally you cannot require employees to be vaccinated to work, with some exception. I still believe that to be the case in Florida, as I read, if I broadly read the law, with the exception of maybe healthcare employers and some other employers. And there's a number of exceptions, even when the vaccine will be required. For instance, we'll see again some mention of the ADA, the Americans with Disabilities Act. If you have some indicated potential adverse reactions, contraindications to the vaccine, you would be potentially exempt. But this is the two federal agencies. This is not law. This is guidance. Them saying that in their opinion, the emergency use authorizations do not prohibit the employers from imposing vaccine requirements. Again, not sure how that plays into the overall scheme. I would still be reluctant unless I fit into a specific area where we could require vaccines, like a healthcare employer. I'd be reluctant to impose those requirements.
I think practically speaking, until there's full authorization, I think most employers are going to err on the side of let's not force anyone if it's not fully authorized. So I anticipate that once full authorization does come out, you'll see more employers perhaps as a policy internally requiring vaccinations for continued employment. Or you may have an employer who's a contractor who goes on federal buildings to work on site, and they may need to have that just as a matter of course and practicality for their employees to do their job on federal property to be vaccinated.
So on July 7th, again, we talked the what's been going on from different agencies. Here's OSHA again. This is in here just to show that OSHA has continued to issue and revise its program focused on COVID policies. And a particular note here are these emergency temporary standards, ETS, for COVID and healthcare. So when you go to the OSHA FAQ website for COVID, you will see this list of the emergency temporary standard or ETS that's being continually updated. So that's a reference point for you if you want to highlight that in the materials that you have here. And again, here at the bottom, this is the same website that we put up in the beginning. This is probably the place to check on a regular basis to see what type of what's the status of federal guidance with respect to safety requirements in the workplace. So again, it's a balance of how do we as employers make sure that we're not violating our employees' rights, but how do we create a safe work environment for everybody and a safe environment for any customers, clients, anybody else that comes in the door. So coming into the end of July, now things start to heat up again. You've got we'll touch on the 27th here in a second. The 26th of July, I just thought this was interesting where there's updated guidance coming out again. Department of Justice, this time with Health and Human Services, stating that COVID can be a disability under the ADA and under similar laws. So, what that means as far as an employer, you would be required essentially to make reasonable accommodations for folks with COVID. I think most people are doing that anyway, but that's what the ADA requires. ADA requires reasonable accommodations for to enable not only employees, but for customers and clients and other folks to access your services. Now, does that reasonable accommodation mean that you should let people that have COVID or COVID positive into your facility? That's not how I would read that at all. So I don't want anybody to misinterpret that. But for instance, if you have an employee who tests positive and they want to work from home, I've had clients ask, do we need to let them work from home? Probably the safe answer is during the time that they are suffering from the effects of COVID or are potentially contagious, then you need to make reasonable accommodations to allow them to work if it's possible. There's also some guidance out there that suggests that certain industries need to pay their employees if they are not able to work because of COVID. So if you have questions about that, that might be something good idea to kind of touch base with us later, because this is relatively new guidance and we haven't really seen how that actually plays out in the workplace. This is something that just came out within the last couple of weeks. And as we were putting this together, we announced this a month ago, and I thought that this was going to be, I thought we were going to be talking about the Florida statutes, a couple of early guidance reports, and then you'll see there's a flurry of activity that happened after we announced this. So it really has been, including last night, there was another email that I saw with an update. So this has been really changing on an almost daily basis. Right after that, DOJ Health and Human Services announcement with the CDC revising its guidance regarding masks. And this created a lot of controversy because now the CDC is stating that even fully vaccinated individuals should wear masks indoors if they're in a high transmission area. Again, this is not law. This does not mean that it's required. There are many government agencies, local, state, county governments who are following CDC recommendations. Employers are generally going to be safe if you follow CDC recommendations, even under Florida law, and I'll explain why when we talk about the Florida statute. But again, this was the revised guidance that has really kind of kicked up a storm over the last few weeks. And then the point here on July 29th, when President Biden announced new requirements for federal employees and on-site contractors, note here that if they are not vaccinated, employees must wear masks on the job, which is generally what we've recommended, is that you have a policy that people either get vaccinated or wear a mask. They have to wear a mask on the job, and then they will be subject, these are federal employees and contractors, subject to weekly or twice weekly COVID screening and testing. If anybody's been tested for COVID, you know, it's not terrible, but it's not the most pleasant experience. And if you start sticking things into people a couple times a week, that might be another way to prod those folks into actually getting the vaccine. And there's been talk of, I don't know this for sure. I'd be interested in maybe more feedback on this, but I was told recently that the state of Michigan was requiring kids to be tested on a regular basis. If that's the case, you know, I won't opine on that other than to say it seems borderline criminal. All right, so that's going into July. Early August, we've got, again, OSHA updates its guidance to mirror the CDC guidance. So if you keep checking the OSHA website, you're going to find that. Let's get where it's really exciting. Here in Florida, we are like the center of the COVID controversy universe, outside of maybe now Texas, with the Texas governor testing positive.
They're catching up.
So we're going to go back in time again and look at, you know, how we arrived where we are today. Back last September, almost a year ago, this is where Governor DeSantis sort of announces that we're getting back to normal. So he's going to he issues this order that says that no COVID emergency orders may limit restaurant indoor capacity under 100% unless that order quantifies the economic impact of such limitation and explains the necessity of the limitation for public health purposes. This is where, you know, everything is opening back up in Florida, and people are moving to Florida in droves. Then a few months pass. We get into March of 2021, and there was a lot of talk, and we did a seminar or webinar a COVID related a little over a year ago. One of the issues that came up was potential for an immunity statute. And by immunity statute, we mean some type of protection that protects businesses who try to act in good faith, including business owners who try to act in good faith and follow the guidance that, as you see, is constantly changing and very confusing. And what happens when those businesses, when somebody wants to sue them? Because the plaintiffs' lawyers are out there, and believe me, if they're tracking, the weather app to figure out where hailstorms are happening, so that they can go around and sue insurance companies to get everybody a free roof, those folks are going to be looking for anybody that got COVID, trying to blame an employer and look to sue them. It's a little unfortunate, but that was the genesis of the discussion on COVID immunity. There's been talk of a federal statute. There is not one that exists or is even really seriously in play that I'm aware of, but Florida does have one. It's 768.38 of the Florida statutes that provides civil immunity to individuals and businesses from COVID-related claims, as long as they make a good faith opportunity to comply with public standards, public health standards. Immunity essentially means you can't be sued, or if you are sued, the case is quickly tossed out. So we'll take a look at the statute, because I think this is very important. It's probably one of the most important things we're going to talk about for business owners and employees today. And some of the things to notice here is that this is all required by statute with respect to these claims. I have not found a case yet interpreting this statute or where it's been challenged. So right now, this is the law in Florida. If you're going to sue an employer or a business owner, a business or a person, if you're going to sue somebody for a COVID-related claim, essentially claiming that they took some action or were negligent and caused you, let's just say you're going to file a claim for negligence against an employer because you contracted COVID in the workplace. What are your chances of success? Well, first, you have to plead that claim with particularity. This language comes, if anybody's familiar with, I know we have some lawyers on this call, this is the requirement of pleading a claim for fraud. And it's a higher level of pleading. So when we say as lawyers that, well, anybody can sue for anything, or anybody can file suit for almost anything, and you have a chance of keeping it alive in the early stages, that does not apply to a claim for fraud. When you're talking about fraud and you have to plead it with particularity, you're talking about the who, what. Let's just say somebody lied to me and caused me to do something I would have otherwise done, and I lost money. Well, who lied to you? What did they say? Was it written or was it oral? How did you rely on it? How did you change your actions based on what that person said? When was this message? When did you take your action? And how are your losses or damages directly related to the fraudulent or alleged fraudulent statement? That's the type of stuff we're talking about with particularity. And here you've got in this statute that if you're going to file a complaint, either representing a party with COVID, or are you complaining that you are being you've been injured by in somebody's negligence due to COVID, you have to plead that claim with particularity. Exactly what or who did what or failed to do something. Who was it that did it? That's the person you're suing. What did they do or fail to do in detail that caused you to get COVID? And then once you file your complaint, it must be supported with a sworn affidavit of a physician who attests within a reasonable degree of medical certainty that the damages that you allege, or the injury you're saying that happened, were caused by the acts or the failure to act by the defendant that you are suing. This is similar to, we have a higher standard for medical malpractice claims in Florida, where you have to meet certain hurdles before you can just sue for medical malpractice. We see this standard suing when it comes to suing other professionals. For instance, I was involved in a case a few years ago up in New Jersey where there were claims against a lawyer for malpractice, and New Jersey would require, before you can sue a lawyer for malpractice, that another lawyer sign a sworn statement saying that there's actually a claim here. It is another factor that creates a barrier to bringing COVID-related claim.
Practically, Eric, I mean, are there many physicians who would be comfortable making such an affidavit, or would they even be willing to sign anything, even if they do think that there's an issue, put their name on something and kind of put it out there that they're the doctor that's willing to support an affidavit like this.
That's a great question. It remains to be seen. My suspicion is yes, that you will find some. Will you find some that aren't hacks? That will just say, I mean, you know, what will happen potentially here is either nobody will agree to this, nobody will sign, or you'll get the same few people signing. I'm not. I would be interested to hear from other physicians if this is something that they would consider doing, that they would look at this. Now, there may be some cases. This isn't to say that there's not going to be cases where people are obviously negligent. And those cases should be brought. But this isn't a complete bar. This immunity statute isn't a complete bar to bringing a COVID claim. It's just creating a higher standard so the floodgates don't open with the plaintiff's lawyers suing everybody. And I think it is. I think you raise a good point, Kathryn. It's going to be tough to find physicians who are going to put their reputation on line. Because once you sign that statement, you become a witness. And you're going to be, the physician will be an expert witness. They're going to be subject to cross-examination. You're going to be asked, you know, how did you come to that conclusion? You know, what information did you rely upon? What did you look at? And how did you come to the conclusion that the defendant in this case did some act or failed to do something that led to the damages that the plaintiff is alleging? And it gets even tougher, and we'll dig into that here further in the statute. But this is the initial requirement, that the physician has to sign this sworn statement attached to a complaint. And from there, the first thing that happens is the court must determine initially whether the plaintiff meets the pleading requirements, and then whether the plaintiff, if they've pled properly, that the defendant has failed to make a good faith effort to comply with legal authority or controlling government standards or guidance. And we're going to get into that a little bit further on the next slide, what that means. But there's also a higher pleading standard and there's a higher proof standard. And the physicians contemplating signing this type of affidavit need to be aware of this. And so do anybody who's thinking about bringing this claim or if you're defending a claim. The burden is, the burden of proof is always on a plaintiff to prove their case. But what often happens in lawsuits is a plaintiff brings a case and the defendant can raise an affirmative defense. And an affirmative defense may be something like, yes, I know you were injured at work. I know that you contracted COVID on the work site or on the job site or in our business, but we acted in good faith. And when the defendant says yes, but, that's typically an affirmative defense, and the burden of proof would shift from the plaintiff to prove its case, negligence in this case, to the defendant to now prove they act in good faith. Okay, what did you do to act in good faith? Here, the statute flips that on its head, and the statute says that the burden of proof is on the plaintiff to prove the defendant's absence of good faith. In other words, the defendant is presumed to have acted in good faith, and the statute gives us more. This is actually, I think, a well-written statute. A lot of thought went into this. The statute gives us more language to show the types of things that a defendant can bring up to further support good faith. First, the plaintiff has to prove that the defendant didn't. I'm not sure how you prove a negative. You really have to allege that the defendant had all this material available, all this information available, and just completely flew in the face of it. And if that's the case, by the way, then you have a good claim. But if you look at this second bullet here, where we have the language regarding standards or guidance, and this is similar to what we'll see in a Norwegian case. What if you're looking at OSHA, but you're looking at Florida, and you're looking at other local guidance, and maybe the county has a different requirement? You say, look, I didn't know what to do. We did what we thought was best, but this is the guidance that we followed. And what the statute says is if there's more than one source or set of standards or guidance that's authoritative or controlling at the time the claim accrues, that's when the plaintiff says they contracted COVID here, then the defendant's good faith effort to comply with any of those sources or standards confers immunity. So the defendant can say, look, here's what I followed. Yeah, there were conflicting, and the plaintiff can come back and say, well, the CDC said this. That's what we'll hear. Like, the CDC said this. And you, where we are, Seminole County, Orange County, you had different guidance. You should have followed the CDC's recommendation. You didn't. If you're an employer and you say, look, Seminole County, Orange County, Governor DeSantis, Florida is saying this, it contradicts the CDC, but I'm going to follow Florida because it makes more sense to me, you're going to have immunity. And only if the plaintiff can get over those hurdles can the plaintiff bring the claim. But then once the plaintiff brings the claim, the plaintiff has to prove it by gross negligence and clear and convincing evidence. Gross negligence is a higher standard than regular negligence. So if you brought a claim based on negligence, it's automatically going to get tossed out. You'd have to allege at least gross negligence, which is basically the defendant knew there were better ways to do things and just totally ignored them. It wasn't that they didn't look up something; they were told, look, you need to have better policies, and you ignore it. The clear and convincing evidence standard is a higher evidentiary standard. Normally, to anybody who watches criminal shows or trials or is in that business, you know that the standard for proving criminal liability is beyond reasonable doubt. Most court cases based in negligence or violation of a statute where there's a civil liability, usually it's just a balancing test of a burden of proof. So the court will look at the scales and figure out, or a jury is to look at the scales and figure out which side has done a better job of proving their case. But the clear and convincing evidence standard is a higher standard. And so if you have to prove gross negligence by clear and convincing evidence, that's going to be tough to do in a COVID environment, to prove that somebody got COVID by your gross negligence and they didn't get it somewhere else. And that's why I said, Kathryn, in response to your question on the doctors, are people going to sign this? I think that any physician considering signing that affidavit needs to be made aware of and needs to be aware of that standard. Are you going to sign that affidavit that says that clearly and convincingly the evidence that you've reviewed shows that the plaintiff was the defendant was grossly negligent? That's a tough standard. And then we also have a shortened statute of limitations. You got 1 year to bring a claim. So if you think you got COVID and it was April of 2020, it's too late. You need to bring that claim sooner. Now there is some language in the statute that does say that this statute applies both retroactively and prospectively. Statute came out just earlier this year, and if you already had filed a claim, this is the language in the notes of the statute. If you already filed a claim and that claim is existing before the statute came out, then the claim is not affected by the statute. But anybody else would have a claim that would have accrued. Statute came out again. What was the date of this? Was March of
29.
March 29. So if you say, well, I have a claim that accrued last December, so am I subject to the statute? The answer is yes, you are subject to the statute. You are essentially what we would call grandfathered, or your claim is not grandfathered in. Any claim that gets brought today is going to be subject to the statute.
I also did want to mention, Eric, in the definitions in this statute, they define what a quote COVID-19 related claim is very broadly. And that's basically a civil liability claim which arises from or is related to COVID-19. So in your example, that's so direct, you got COVID because of someone's negligence or gross negligence. Take it a step further. Let's say, somebody calls for an ambulance and they can't get one, or they can't get a bed in the hospital. They don't have COVID, but they have something else that cannot be treated with urgency because the resources at the hospital or the ambulances are devoted to COVID cases. So I think that would probably be slipped into this broad net of what a COVID-19 related claim is. And so I think that just kind of shows the legislative intent of trying to, as best they can, shield business owners and individuals from liability, in a legal landscape that is so uncertain and is constantly changing.
That's a great point. I'm glad you pointed that out. I think this is I like this statute. I think I think it's necessary to get businesses open again. Most people I talk to, I think we both talk to, are business owners and employers that are trying to do the right thing, and they are scared. And people are afraid that a foot fault is going to get them sanctioned either criminally or administratively or legally in some sense. And the lawyers, we're looking at this, the two of us sitting here looking at this material, trying to make sense of it. So I think this is going in the right direction. I know there are bad actors out there, and there's other mechanisms to get to those bad actors, but I really think we need this to get the economy going again. I'm glad that Florida took this step in this direction. So that's a little bit of commentary probably beyond the statute. But if you have questions about that, or especially if somebody's making a claim, give us a call. Our contact information is at the back of this. So now a little bit more on Florida. We've got a little bit of time here to cover a couple other points. So now we've got the next exciting point in Florida. Kathryn, you want to talk about the vaccine passports? Get the
Sure.
intro here.
I think you're referring to, well, what's ultimately codified in 381.00316 regarding vaccine documentation. And the statute is interesting because taking a close read doesn't really seem to regulate employers. Eric, would you agree that, and looking at this statute, it talks about business entities may not require patrons or customers to provide documentation certifying vaccination status to gain access to the premises or the business's services, but it doesn't really talk about what a business can or can't do with respect to its own employees. There's similar language for governmental entities and educational institutions.
Now, I had first read this when it was an executive order, and that was referred on the prior pages, Order 2181, before it became a statute. And my recollection, and I would have to go back, my recollection was that the language was a little bit broader than patrons or customers. Yes, generally speaking, I would agree that it doesn't apply to employees, but what if you have, let's just say you are a grocery store, and does this apply to your employees who are also customers, or does it only apply when their customer hat's on but not their employee hat? And then how do you say, well, it doesn't apply when they're a customer, but it does apply when they're an employee because now you've affected the customer? I don't like, in light of the statute, I have not been comfortable with advising employees or employers, unless you fall into a unique circumstance such as a healthcare provider that's exempt from the statute. I have not been in favor of having employers do mandatory vaccines or require documentation, mandatory documentation from employees. Again, that's taking it, maybe reading it in the broadest sense, but I think the better policy is to be encouraging of employees and incentivize them, consistent with what we saw in some of the earlier slides. Maybe give some time off, incentivize your employees to get vaccinated. But I worry about particularly that particular employee who might be a patron or customer of the business.
I think, practically what's going to happen is you're going to have large companies operating in Florida, putting policies in place, and they're the ones with the resources to kind of test this out and see what they can and can't legally do. And I anticipate that once larger companies take a position, whether they require, they require vaccines or they require some sort of self-certification. Yes, I have it. No, I don't, or I choose not to answer. And if you choose not to answer or you don't produce the documentation, then maybe you're required to wear a mask or work from home more.
Well, we've seen that. Actually, Disney and Delta are two companies that have mandated vaccine documentation from employees.
So I think, from a small and mid-sized business standpoint, you kind of look and see what the big guys are doing and see how they test it and what they're able to, how it's going to apply to them, and that may give some guidance as to how it might ultimately apply.
That would be a safe approach. And they were referenced. That's a good segue, I think, into this the recent challenge to the statute that came from Norwegian Cruise Lines. So as a little bit of background, Norwegian Cruise Line was getting ready to set sail from Florida. Obviously, Norwegian leaves Florida, sails in international waters, sails to other countries, sails to other states. And the CDC apparently has issued, there's some ruling or guidance from the CDC. Actually, let me refer directly to that. There's some type of conditional sealing order from CDC. Frankly, I'm not a maritime expert. I don't know what legal authority a conditional sealing order is, if that's something that all the sealing companies, cruise companies agree to. But essentially that requires certain standards of high level of vaccination among crew and passengers. And so generally what the CDC's or what NCL, Norwegian Cruise Line's argument was in bringing this lawsuit against the Florida statute. The suit was brought against, you'll see that the title of the suit is Norwegian Cruise Line Holdings and other affiliates against Scott Rivke's MD, who's the Surgeon General and head of the Department of Health for the state of Florida. And he's just in his representative capacity for the agency that's responsible for overseeing the statute. And Norwegian said, we're subject to all these other requirements, one, and one point is we're subject to all these other legal requirements and these guidance from other agencies, and it conflicts with Florida law. And two, we have a vested interest in making sure our employees and our passengers are safe. And one way to do that is to require vaccine documentation, and the statute prohibits us from doing that. And they brought a legal challenge. They sought a temporary injunction before they were supposed to set sail, and the court issued a 59-page opinion. You can find it online if you're interested in taking a look at the opinion. You can certainly contact me and I can get that for you. But I'll just give you a few highlights of things that came out of that opinion. And ultimately, the court ruled the statute was unenforceable against Norwegian Cruise Lines for a number of reasons. One challenge was a First Amendment challenge. It's a little confusing here for folks if you're not working in this area, even if you're a lawyer and you're not a First Amendment lawyer, which we are not specialists in that area. But the idea was that the court looked at this as a content-based regulation against speech or on speech. And the content-based regulations, because when you look at the vaccine statute, the vaccine passport statute, it prohibits requiring documentation of a vaccine or a prior infection, but it does not prohibit somebody from asking about it and asking you to confirm verbally that you have not been vaccinated. It does not prohibit one thing that the court seemed to think in this case, the court mentioned several times that it does not apply to employers and employees. So really the statute this speech is content-based speech. It only restricts certain speech to certain individuals, that being documentation as it pertains to patrons and customers of businesses. They cannot be requested. And for that reason, it implemented First Amendment concerns, and it becomes subject to strict scrutiny by the courts. And so the federal court engaged in its analysis of the statute as far as whether or not it was constitutional under the strict scrutiny standard. Under a strict scrutiny standard, a little refresher for people in law school, you have to prove that the statute serves a substantial, I should look at the case again, but it's a substantial state interest, and that the statute is narrowly construed to enforce that or to further that interest. And some of the justification that the court or the opinion that the court gave that justified the decision to enter an injunction against the enforcement of the statute against Norwegian Cruise Lines was that first, the statute on its face violated the First Amendment because of this content-based restriction. That's where I mentioned earlier that perhaps the statute could have been written a little bit better. Contrast this to the other statute, which is very detailed, the immunity statute. This statute seemed like it was sort of rushed out. And it might just be a matter of just tweaking the statute. Another issue the court raised was, there's an exemption in here for healthcare providers and clinics, but there's no exemption or exception in here for cruise lines. And so I think that it's also important to read this case, even though it's a long opinion, to read that narrowly if you're going to rely on this, because the court mentions that a couple times, that the cruise lines are in a unique position because they cross state and federal jurisdictional boundaries and go into international waters. So the cruise lines have a specific interest when you're looking, especially at an injunction issue. You have to balance competing interests. The cruise lines have a definite, valid, equitable interest in opposing this statute and pursuing this remedy of injunction that they obtained. The court also points out again that this statute does not apply to employers. I think that's helpful if you're trying to determine, can employers require proof of vaccination? Well, we've got one federal court who said that it does not apply to employers. I would like to see a state court also confirm that, because if you were just going to challenge this on the basis, this statute, if you're an employer and you're just going to challenge it on the basis that it doesn't apply to employers, I'm not sure you can rely on this federal case for that. It gets into federal jurisdiction for other reasons, including the constitutional challenge, but whether or not, who it applies to is a different question. The court points out that, again, that the statute doesn't bar oral or verbal requests for whether or not somebody's been vaccinated. It only prohibits the documentation, and it doesn't prohibit, for instance, obtaining or requiring people to prove negative test results, which we've seen that you have to show a negative test result in order to travel to certain places. Ultimately, the court also found that the statute violated the dormant commerce clause. So this is another one of these law school weird laws, but essentially if you have a state law that interferes with interstate commerce, as this one obviously does for the reasons that were explained by Norwegian in the court and that we've touched upon with cruise lines crossing jurisdictional boundaries, then that statute is subject to being stricken because of its adverse effect on interstate commerce. See if there's any other main points I wanted to hit out of the statute. I also, again, I want to point out that this is one court, the Southern District of Florida, invalidating the statute based on this constitutional issue and also opining on some other issues that were in front of the court, but it doesn't necessarily invalidate the entire. I guess it could be construed to invalidate the entire statute, but the statute is still in place. So if you run directly afoul of the statute, there's a chance here that this statute could, for instance, be amended or revised to eliminate the content-based elements of the restrictions and to broaden the restrictions or change those, and then other pieces of statute may stay in place. So while we do have this one decision, this is also not a final order from the court, it's an injunction. What an order of injunction means essentially is that the court thinks that ultimately at the end of this lawsuit, Norwegian will win. One of the elements that somebody has to prove in order to obtain an injunction is you have to show that after balancing the competing interests, the plaintiff or the party seeking the injunction has shown a substantial likelihood of success on the merits of the case, but it doesn't mean that they have succeeded. So there are other issues that could still come about where the court could say, you know what, this injunction was entered improvidently, and I need to reverse course. I don't see that happening here, but it's a possibility. So again, if you're interested in the case, I've got the whole opinion here all marked up. I don't need to go into it any further. I want to just give you an overview of it. Finally, in the last couple minutes, if you've got any questions, we're happy to field those.
We have one question. For weekly testing, is the employer responsible for the costs?
No, I've not seen anything. Kathryn, have you seen anything? No, and most testing facilities, I still think they're either covered by insurance. I know just recently, I know somebody went and got a test and they were asked for insurance information. I don't know what happens if you don't have insurance information, but I have not seen anything that would require the employer to pay the cost. Now, from a policy perspective, if you suspect somebody has COVID and you want to send them home because they're showing positive symptoms, if they're not insured, does it make sense to maybe pay for the cost? That's a different question, but no, I'm not aware of any requirement that the employer pay for that. Good question, thank you. Let me hit on some other questions. I just go through Nevada. You'll just see that Nevada is taking a little bit different approach, and there's an interesting point here. And you've got these slides. You can read this. Here again, Nevada started to open everything up right around the time Florida did. Maybe a little bit later. I have actually happened to be in Nevada right around the time the casinos were getting ready to go to full capacity. But Nevada has more followed the CDC guidance, more so than Florida has. But every state's got their own interests. So keep that in mind as well here. So Nevada's got this law that was passed. It's the Nevada Hospitality and Travel Workers' Right to Return Act. And essentially, as I read this, what it essentially says is that folks who are laid off from their casino and hospitality jobs have to be offered reemployment. And if they're not offered reemployment, then they have certain remedies under the act. So if you fall in that category, if we have anybody from Nevada out here, we can opine on that a little bit more. And then I also like this. Here's a couple other things from Nevada in June. I found this after I had worked with some employers, some clients on an employer policy where I suggested giving something like 4 hours of time off so that people can go get vaccinated and allow them to recover or take off for the rest of the afternoon. And Nevada essentially passed a law that has this same, this makes it a legal requirement. And here you see the same as federal requirements requiring where some state employees will be required to submit to weekly COVID testing. I don't know if they'll do that on premises, off premises, they'll have to go somewhere. You're going to get that little thing that goes into your nose or something else. But that right there may prod some other folks into getting COVID tests. Thank you, folks. Have a great rest of your day.
Bye-bye.